Mr. Deputy Speaker, the SICC, of the Singapore International Commercial Court, was, as we've heard, officially launched on 5th January 2015. And since then, the specialist division of the Singapore High Court has grown from strength to strength. The court benefits from the best features of our established judicial system in Singapore, as well as some novel features, such as having eminent international judges with common law and civil law training and experience who may be designated by the Chief Justice to hear cases at the SICC from time to time. London may still dominate cross-border commercial litigation, but it is no longer the default venue. The SICC has proven that it is able to quickly resolve complex disputes of substantial value, and together with the SIAC, the Arbitration Centre, and the SIMC, the Mediation Centre, is an important component of Singapore's standing as a leading dispute resolution hub of choice in Asia. It is thus only fitting, Mr. Deputy Speaker, that on its third-year anniversary since its launch, amendments have been proposed to the SCJA to clarify that the SICC has jurisdiction over all international commercial arbitration matters. This court that had prompted the SICC's creation, the London Commercial Court, is perhaps one inspiration for this particular amendment or this particular clarification, as just like the London Commercial Court has a relationship with the London Mercantile Court, the SICC perhaps can be a specialist international court for international arbitration matters as well. The amendments to also abolish pre-action certificates signify that the SICC has come of age. I welcome these amendments, sir, but permit me to ask and pose certain questions to the Senior Minister of State. First, notwithstanding the current avenues for enforcement at common law and under statute, does enforcement remain a challenge for the SICC as far as its judgments are concerned? More specifically, has Singapore's ratification of the Hague Convention on the Choice of Court Agreements in 2016 and the passage of enabling legislation by this House just last year had a positive impact on the enforcement of the Singapore High Court's judgments in general and the SICC's judgments in particular? If so, could the Minister please elaborate? In addition to typical commercial arbitration cases, which are between two commercial parties, do the amendments also clarify that the SICC can sit, if certain conditions are met, as the supervisory court in investor-state arbitration cases as well, under the International Arbitration Act, particularly Section 10 of the International Arbitration Act? It would stand to reason, sir, that it can do so, since the High Court and the Court of Appeal have exercised such jurisdiction in the case of Sanlam Investments and Lau, but I ask for this clarification from the Minister, as a jurisdictional challenge was recently raised in the 2017 case of the Kingdom of Lesotho and Swissbro Diamond Mines. Further, some scholars believe that a Singapore court may not have jurisdiction under the IAA to serve as the curial court in investment arbitration cases. 4, given that the SICC has, strictly speaking, had the jurisdiction to hear cases arising from international commercial arbitration, both when the parties so agree by written agreement, as well as when there's been a transfer from the High Court in its original jurisdiction, what may have dissuaded commercial parties from agreeing in their dispute resolution clauses thus far from having all court actions arising from any Singapore-related arbitration to come before the SICC? Are there statistics to show the number of companies, perhaps, that utilize the existing SICC model dispute resolution clause in their agreements? Finally, are future innovations in the pipeline, sir, to enhance the recognition and enforcement of SICC judgments? At the DIFC court, the Dubai International Financial Center Court, I note that money judgments can at times be converted under their practice directions into arbitral awards for the purposes of having recourse to the widely accepted New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. At the DIFC, if the judgment debtor does not have assets in Dubai, a common law country, a GCC country, a Gulf Cooperation Council country, and or a country with which UAE, the United Arab Emirates, has a bilateral or multilateral treaty on recognition and enforcement, the judgment creditor can nonetheless still commence arbitration under the arbitration rules of the DIFC LCIA Arbitration Center. It's a combined center between the London Court of International Arbitration and the DIFC. While the nature and scope of the DIFC are certainly different from the SICC, is the Ministry of Law perhaps studying the prospect of anything similar in collaboration with our own SIAC, which itself is recognized as one of the top 5 arbitral institutions in the world? Just as an experimental practice direction that I mentioned above has opened the door to wider enforcement of DIFC judgments across the UAE, is the ministry currently looking into the possibility of enhancing the recognition and enforcement of SICC judgments in ASEAN and Asian countries beyond the current venues of enforcement available at common law and under statute? Let me end, sir, by saying perhaps that the Senior Minister of State would be the person best poised and best positioned to answer my questions, as she herself was a member of the creating committee of the SICC in 2013.